Brother Justice P. Navin Rao, Judge High Court for the State of Telangana and Executive Chairman of Telangana State Legal Services Authority, my distinguished colleagues on the bench, Member Secretary Mr. Govardhan Reddy, Registrar General, Registrars of the High Court, Principal District Judges and Judicial Officers of the districts, officers and staff of the registry, friends from the media, ladies and gentlemen. At the outset, I wish all of you a very happy and a successful 2023. Let us hope and pray that our shortcomings, which we noticed in the previous year, will be a thing of the past and will be able to achieve collectively newer heights and newer goals. With this optimism, I am delighted, in fact, to virtually inaugurate the 23 district legal services authorities. Friends, we all know that district legal services authorities, constitution of DLSS is traceable to the Legal Services Authorities Act 1987, which in turn is traceable to Article 39A of the Constitution of India, which in turn is traceable to the 42nd Amendment made in the Constitution of India in 1976. Legal aid, as we know today, is part and parcel of our judicial vocabulary, judicial system. Access to legal aid is a part of or a facet of Article 21 of the Constitution of India. But it was not always so. In the initial days of the Constitution, there was a case from the Punjab, Take Singh, the case of Tara Singh versus State of Punjab. And in that case, Supreme Court, in the context of Section 340 of the Old Criminal Procedure Code 1898, held that right of an accused person to a lawyer was a privilege given to him, and that it was his duty to ask for a lawyer if he wanted to engage one or to get his relations engage one for him. This was in AR 1951 Supreme Court 411. From 1951 we have come a long way thanks to the decision of the Supreme Court in Menka Gandhi, whereafter Article 21 has received very liberal and dynamic interpretation of the Supreme Court. There are innumerable landmark judgments where Supreme Court has interpreted Article 21 in the context of Article 39A, which is a directive principle of state policy. In the first case, Madhav Hoskote versus State of Maharashtra, this AR 78, Supreme Court held that right to free legal aid is a guaranteed fundamental right under Article 21. So this is a new dimension brought in by the Supreme Court. Thereafter, we have this series of Husainara Khatun cases from Bihar, where it was held that right to speedy trial was within the sweep of Article 21. Sukhdas versus State of Arunachal Pradesh, Supreme Court held that a trial without offering legal aid at the expense of the state will be vitiated and conviction will be set aside. So this is how the law has evolved. Thereafter, there are several landmark decisions from Prem Shankar to Citizens for Democracy to Kadra Pahadia to Francis Corelli and then to Sila Barse cases, and of course the series of Sunil Batra cases. Now it has clearly evolved that whether one is an accused at the stage of investigation or an under trial prisoner at the stage of trial or a prisoner post-conviction, he is entitled to be treated with dignity befitting a human being, and that legal detention does not mean that a prisoner is denuded of all his rights, or can he be ill-treated or tortured in detention. Just because one is a prisoner, it does not ipso facto mean that all his fundamental rights will desert him at the prison gates. These are the words, the golden words of Justice Krishna Iyer. The impact of the judgment was so profound that Parliament had enacted the Legal Services Authorities Act in 1987, providing for a three-tier system of structured system of legal services authorities. We have NATSA at the apex level, then we have the state legal services authorities at the state level, and of course the district legal services authorities at the district level. Till now, we had in tandem with, in tune with the 10 districts, we had 10 legal services authorities. Now, after the co-terminus creation of additional districts, we had to create these 23 district legal services authorities. I must thank the state administration for their valuable cooperation. Otherwise, creation of these 23 DLSs would not have been possible in such a short time. So, friends, it is a momentous occasion. We have now full strength DLSs. It is not, I always say, it is not charity that we are doing by giving legal aid. It is our constitutional duty on each of us, judges, lawyers, legal aid counsel, legal aid volunteers, paralegal volunteers. It's our constitution.
During the period from January 2022 to December